Hi, I'm Kylene Stemmons of Georgian Law, and I'm here with senior case analyst Eric Phillips.
Hi.
Eric, let's talk about what the options are when you're upside down in your property or behind in your payments.
Well, there are four basic options: loan modification, short sale, deed in lieu, or foreclosure.
Okay.
And there really aren't any additional options other than that. It's just those four things. So what we do at Georgian in our analysis and our consultation with our clients is we'll sit with a client and we will explain all four options and try to decide what path they should take. You have some clients in a loan modification, even though it typically doesn't reduce the balance, but it makes the payment affordable, and you have a family that doesn't want to move and has several children, they don't want to uproot the children, and they're going to be in that property for a long time, then it makes better sense for that client possibly to modify the loan, take the tax break, and not uproot the family. When we talk about deed in lieus, to me, I would never do a deed in lieu of foreclosure. Deed in lieu actually means deed in lieu of foreclosure. Not only do you have to maintain the property in move-in condition, you have to list with a reputable broker, you have to list for a minimum of 90 days, you have to submit all offers to the bank, and then if the bank agrees to it, they'll issue the deed in lieu. The problem with the deed in lieu is the deed in lieu of foreclosure document is a publicly recorded document that goes against your credit, and because it's public record, it stays there for 10 years. So I personally don't see the value in doing a deed in lieu.
Okay.
Now, in terms of a short sale, the advantage to the short sale, as we all know, is we have a shorter closing period. We have the reduction and elimination of liability on the notes, which is hugely important.
Right.
Okay, and that to me is really the main benefits of doing a short sale. And of course, with a foreclosure, we've exhausted all options, and we just let the property simply proceed on, and the bank will retain possession of the property.
Right.
And sometimes that's the best position for a client because it allows the client to stay in the property for a longer period of time, hopefully accumulate some dollars, so when the property does revert back to the bank, they can move on to another property from there.
Can Georgian Law expunge all four of those options from a person's credit?
No. No, we cannot. First of all, there's nothing that's recorded against you regarding a loan mod, so we're not worried about that. There is not a legal procedure to remove a deed in lieu document, a deed in lieu of foreclosure. However, when you do a short sale or you do a foreclosure, we are able to do our judicial expungement. That obtaining of that court judgment will cover the removal of the short sale or the foreclosure activity from all applicable databases.
Perfect, thank you.
Okay, my pleasure.